Court dated 15th January 2026 for removal of the election materials from IEBC to Embu High Court. The report is dated 27th January 2026. In it, the DR recorded having received the following boxes from a strong room of IEBC offices in Embu. 134 ballot boxes, namely one from each polling station. One box captured as the 135th ballot box delivered at the tallying center. 4 boxes recorded in an, quote, inventory of other strategic materials issued to Embu High Court for the Mbeere North by-election petition, unquote. And finally, 15 boxes containing Kim's kits. Of the 4 boxes in the inventory of other strategic materials issued to Embu High Court for the Mbeere North by-election petition, that was box number 114337, it contained, amongst other things, 1,072 Forms 32, declaration of secrecy, made by a person assisting a voter. Naturally, this inventory raised concerns as to why these materials were produced from the IEBC offices at Embu without any record by the returning officer. Accordingly, in its ruling, paragraph 62 and 4, delivered on 27th March 2026, the court ordered scrutiny of other strategic materials issued to Embu High Court. Following scrutiny by the DR, she reported her findings at page 15 to 19 of her report of 17th April 2026 as follows: that there were 1072 Forms 32, folio marked 1 to 1072. Out of these, 10 were blank or unpopulated in any way, blank forms. There were forms by 6 declarants which had filled forms, by 6 declarants who had filled forms twice, of whom 2 declarants filled 2 forms at 2 different polling stations, while the other 4 declarants each filled 2 forms at 1 station. That is all contained in table 4 of that report. RW1 testified that at the tallying center, he received 134 ballot boxes. He also stated that he handed over to the DR 135 ballot boxes, with 1 box containing strategic materials. He stated that he prepared box 135 out of good faith. On the one hand is the cardinal rule on adversarial litigation, that parties are bound by their pleadings, ensuring procedural fairness, certainty of issues, and protection against trial by ambush. On the other hand, there is the constitutional duty imposed on election courts to safeguard the integrity, verifiability, accountability, and transparency of elections under Articles 86 and 81 of the Constitution. It is a substantive rule of adjudication that pleadings have a binding force. In IEBC versus Stephen Mutinda Mule and others, the Court of Appeal stated in unequivocal terms that parties are bound by their pleadings and that evidence which departs from the pleaded issues goes to no issue and must be disregarded. The same logic was reiterated in Raila Odinga and 5 others, Supreme Court Petition number 5 of 2013. There, the Supreme Court emphasized that parties are bound by their pleadings and evidence must be confined to pleaded issues. Similarly, the Supreme Court in Zachariah Okoth Obado and Edward Oyugi, Supreme Court Petition 37 of 2014, reinforced the position that election petitions are strictly framed disputes. Respondents are entitled to know with precision the case they must meet, and the court is equally constrained by the issues framed in the pleadings. This establishes pleadings as the primary jurisdictional boundary of electoral adjudication. Against this strict framework, the Supreme Court in Gatirao Peter Munya versus Dixon Mwenda 2014 set out the governing logic on scrutiny, which is that scrutiny is not a fishing expedition. It is a verification mechanism tethered to pleaded allegations. The court was clear that scrutiny cannot be used to discover new causes of action or to sustain a petition that fails on its pleaded grounds. However, the court also recognized a controlled opening, namely that where scrutiny is properly ordered, particularly by the court itself, as in this case, what emerges may be interrogated by the parties and evaluated for its impact on the integrity of the result. Can courts therefore ignore serious electoral irregularities that emerge from scrutiny? Where scrutiny is triggered by a party's application, its scope is strictly confined to the pleaded issues and the specific polling stations in dispute. It cannot be used to enlarge the petition or introduce new grounds of challenge, as several cases cited. By contrast, where scrutiny is ordered suo motu, which is, I think, what this court did, the court may direct scrutiny as part of its case management powers to clarify the evidentiary record, but this does not expand the issues for determination or convert scrutiny into an inquisitorial process. Any irregularities emerging from the scrutiny remain subject to contestation by the parties and must be evaluated within the pleaded issues and the constitutional standard of electoral compliance. The question whether the court should turn a blind eye on malpractices arising from scrutiny was focused on in the Musikari Combo case, 2014, where the court held that an election cannot turn a blind eye to serious electoral malpractices revealed during scrutiny or recounts simply because they were not pleaded. The court justified this exception on constitutional grounds that electoral justice cannot be reduced to procedural technicalities, where the process itself is shown to be fundamentally compromised. In Peter Kingara versus IABC 2014, the Court of Appeal emphasized that scrutiny is not an avenue for building a new case. That position was reaffirmed in many other cases, and I've cited a number of them. The courts have reiterated that scrutiny must remain tethered to pleaded issues unless exceptional procedural safeguards exist. That caution was emphasized also in Walter Nyambati case, 2018, where the Supreme Court stated that scrutiny is not a fishing expedition, cannot be used to latch onto whatever evidence to construct a case not pleaded. I've cited Abdikadir Hussein's case, the 2023 High Court. Kenya Court of Appeal, where the Court of Appeal introduces a decisive procedural safeguard that even where serious irregularities are revealed by scrutiny, an election court cannot rely on them without first placing the adverse party on notice and affording an opportunity to respond. The court treated this not as a discretionary courtesy, but as a requirement of due process, and pleaded material cannot silently or automatically mature into grounds for nullification. In the present case, and as already pointed out, the issue of assisted voters featured significantly in the petitioner's supporting affidavit and upon hearing of the evidence of the petitioner's witnesses. The respondents thus had a full opportunity to deal with the issue. It was evident as far back as was recorded in the DR's report on movement of the preservation materials and in the petitioner's witness affidavits. There was no ambush, in my view. In its decision in Kombe versus Karisa and three others, 2024, Kenya Supreme Court, the Supreme Court affirmed the core principles in Munya on scrutiny. The Apex Court stated as follows at paragraph 107, the Court of Appeal relied on the decision of the Supreme Court in Munya that scrutiny is a vehicle to assist the court to verify the allegations made by the parties to the petition, which allegations themselves must be hinged on pleadings, that it was never intended to enable the court to unearth new evidence on the basis of which the petition could be sustained. From the record, the Supreme Court accepted that the trial court had engaged extensively with scrutiny findings such as unstamped counterfoils, polling station inconsistencies, and irregularities in statutory forms. The Court of Appeal had criticized reliance on some of these matters as unpleaded. The Supreme Court's reaction was not to abandon the pleadings rule, but to recharacterize the function of scrutiny evidence within the broader evidentiary inquiry. It held in substance that scrutiny findings do not operate as stand-alone causes of action, but neither are they legally inert simply because they were not expressly and specifically pleaded. At para 108, the Supreme Court noted as follows, it would appear therefore that the report of scrutiny did not yield the outcome expected by the first respondent when he sought it. That did not preclude him from presenting and relying on other pieces of evidence to illustrate that the election in question did not conform with the constitutional and legal imperatives. In the present case, the question of assisted voters was not specifically pleaded, as already stated. Nevertheless, it does not arise entirely as an ambush. Since the petitioners supporting affidavit and the first to third respondents replying affidavits took notice of the issue. When the court ordered scrutiny of the assisted voter forms, this emanated from the fact that they were produced for preservation without any record as to how they found their way into the box and files. They were delivered in. The court was thus entitled to order scrutiny thereof since oral evidence had been taken and no proper account of the Forms 32 had been given by the respondents. Thus, scrutiny was duly ordered and forms part of the evidential matrix. In my view, the outcome of the scrutiny may be used in aid in evaluation of whether the totality of the electoral process met the constitutional threshold of integrity, verifiability, and accountability. The decisive question is not whether each irregularity was individually pleaded, but whether the election, taken as a whole, complied with the constitutional and statutory standards. The authorities hold as follows, and I've cited Mohammed Abdi. Let me read it. Where the Supreme Court majority refined the remedial approach to Regulation 72, non-compliance, by requiring that such breaches be assessed within the broader Article 86 framework of verifiability and materiality, rather than be treated as automatically determinative of electoral invalidity. Where in the first instance the failure to mark the register is isolated or inadequately proved, the courts generally decline to nullify elections, although the failure weakens the credibility of the official account. This was the position in Mohammed Mahmoud Ali versus IEBC, Mombasa High Court 2017. Further, if the failure becomes systemic, particularly in constituencies where assisted voting would predictably be widespread, courts may infer that the process itself became unverifiable. In light of the foregoing analysis of the law, this court can now make the following conclusions. First, that Regulation 72(6) of the Elections General Regulations was violated in respect of the 1072 assisted voters, as they were not recorded in the physical register as required, nor was there evidence that they were indicated as such in the KIMS register or PSD. Secondly, that the only evidence available that there were assisted voters is the existence of Form 32, which is the declaration of secrecy, in compliance with Regulation 72.5, indicating the declaration of secrecy by persons that assisted the said voters. Thirdly, with regard to double declarations by the 6 declarants earlier discussed as found during scrutiny, these were in breach of Regulation 72.5 of the Elections General Regulations, which provides that as follows: the following shall apply with respect to a person who assists a voter under this regulation. The person shall assist or support only one voter at that election and have a mark of as proof of assisting or supporting a voter. Fourthly, while the court take the position that all assisted voters' votes be struck off, it would not change the result of the election, as it is impossible to identify for which candidate they voted. Finally, taking into account the caution of the superior courts concerning unpleaded issues and considering these violations cumulatively with the other irregularities pleaded and on which evidence was availed and has been evaluated, I am not satisfied that it was ultimately shown that the results did not reflect the will of the people in relation to assisted voters. Conclusions and disposition. On issue 1, the court found that the evidence of the petitioner did not list the IEBC officers in issue, did not identify which of the officers were opaquely. Actually, I've just reiterated, I have plucked from the body of each conclusion, I have brought it back to the conclusions and disposition. So that on issue 1, I find that no qualitative disqualifying attribute in appointment and dismissal of IEBC election officials was demonstrated. On issue 2, again, I have plucked the conclusion I reached under that issue and brought it forward. It was demonstrated by evidence that there was a physical register, voters register available at every police station, that it had a QR code, that the KIMS kit had a soft copy replica of that register. No evidence was availed that any voter was disenfranchised, since the physical registers were present and were also replicated in the KIMS kit. Then I point out the jurisprudence on the use of the physical register is essentially what is carried in the UDA case, that such register is only to be used in instances where biometric or alphanumeric identification fails. The UDA case, I may say, does not entirely deal with Section 72, Regulation 72. It doesn't entirely with regard to assisted voters. There was no evidence of such failure of identification. The prevailing jurisprudence on the use of registers is the UDA case, is that such register is only to be used in instances where biometric or alphanumeric identification fails. There was no evidence of such failure of identification. Had there been a failure of biometric and alphanumeric identification, followed by failure by IEBC to deploy the physical register, a case of voter disenfranchisement would have been readily made out. On issue 3, whether there was unlawful third-party interference, on this I came to the conclusion that it was not proved that admitted interference with the register was either widespread, systemic, or intended. In substance, therefore, there was no proof that of the fact that the sole instance of interference that we saw in the case of Collins affected the will of the people. It was also held that in the case of one individual, where the register was shown to have been unlawfully altered, the officer involved may have committed a criminal offense. On issue 4, the same summary that I take the same summary or conclusion, and this is where I said Kaungu theoretically suffered a turnout decrease of about 8% or 51 voters as against the constituency average. But I found overall the failure did not affect the outcome in terms of Section 81 of the Elections Act. Section 82, sorry, of the Elections Act. On issue 5, whether there was bribery treating, maybe I just read all of them, if you don't mind. Let me just read all of them so that I don't give an impression. On issue 5, whether there was bribery treating and undue influence in violation of the Election Offences Act and the Constitution, there was uncontroverted evidence of bribery involving 2 witnesses. As an election court, this court can make a determination only on whether the election malpractice, whether an electoral malpractice of a criminal nature may have occurred in terms of Section 87 of the Election Act, but not on whether the offence of bribery was committed. I do find that an electoral malpractice of bribery may have occurred. As to whether the electoral malpractice of bribery and voter influence so found results in the nullification of the election, the evidence does not show that the scope and prevalence of the malpractice substantially affected the result of the election in terms of Section 83 of the Elections Act. On issue 6, whether there was broken chain of custody, unlawful handling of election materials, and violation of procedure on close of polling, the totality of the evidence availed disclosed that out of 134 polling stations, there was broken chain of custody, possible unlawful handling of voting material, but no violation of poll closing procedure at Gitiburi 1 and 2, except with regard to the time. For Kaungu, there was evidence of violence, but no evidence of broken chain of custody, unlawful handling or violation of poll station closing procedure. Consequently, there is no basis for a finding that the irregularities or non-compliance were substantial and affected the election outcome in terms of Section 83(1) of the Elections Act. Had it been demonstrated that the sort of violence shown at Kaungu was pervasive or widespread, a positive case would have been made out to conclude that the violence affected the overall quality of the election and had a significant impact on the result. Issue 7, on whether there was use of state resources, state security offices to influence the voters. It was incumbent on the petitioner, in order to prove issue 7, to provide at least the minimum information or proof, the names, some of which were provided, their formal designations, the offices held, and particulars and nature of the alleged abuses of such offices, provisions of the law breached, and the overall effect of such abuses upon the electorate and the election outcome. The petitioner failed to provide these through the evidence adduced. Accordingly, the court is unable to find in his favor on this issue. On issue number 8, the same, the court was unable to find in favor of the petitioner, the same on even the assisted voters. Because with the assisted voters, what I have done is that I have said I take seriously the caution by the superior courts concerning unpleaded evidence gathered through scrutiny. The outright determination, the overall determination, for all the foregoing reasons, the court finds that the petition was not proved to the required standard, and it is hereby dismissed with costs. The costs are as follows. The parties made submissions on costs, generally to the effect that costs follow the event. The first to third respondents' counsel went into some fair detail in indicating the depth of the case, the number of attendances, preparatory time, complexity, and so on. The first to the third respondents and the fourth respondents both indicated that costs should be at Kenya shillings 5 million. The petitioner only submitted during highlighting. So having considered the nature of the case and the input of the parties and noting the fourth respondent did not testify to or avail witnesses, I hereby cap party and party costs at Kenya shillings 4 million. The first to third respondents shall be entitled to 70% thereof, and the fourth respondent to 30% thereof. I have prepared a report of the court on electoral malpractices under Section 87 of the Elections Act, which is as follows. The court finds that the following malpractices of a criminal nature may have been committed and directs that the same be transmitted to the DPP. A, admitted alteration of register without authority, contrary to section 6.